May
it please the Court, Your Honors. My name is John Garber. I represent the appellants in this case. And this is a zoning case arising under Chapter 40B. I represent 26 appellants who are residents of a neighborhood near the project which is at issue on this appeal. It is a project proposed by HAP, one of the appellees, and it was approved by the Amherst Zoning Board of Appeals, also an appellee. Our position is that the Zoning Board of Appeals and the Land Court used the wrong standard in evaluating the comprehensive application, which is the subject of this appeal.
Can I, just before you get into that, can I ask you what authority the Zoning Board had to impose the 20% quota on the other question that's here? Is there any authority that they had to impose the 20% quota?
Authority in what sense, Your Honor?
Authority. Did they have any regulatory, statutory authority? Where did they get their authority to impose this quota, the racial quota, the percent of the 20%?
That I'm not sure of, Your Honor. I don't know what authority they purported to offer in support of that. I do know that it is a part of the final decision.
Okay.
In particular,
if I can just, while you're on that, I know you want to get to the main piece, but if we could just do that. If this Court determines that the 20% quota is not authorized by law or contravenes some law, does that, what is the appropriate relief? And I'll ask Mr. Garber the same question. In other words, there's a permit for a low and moderate income project. The statute, as I understand it, provides that you've got to have X number of units set aside for individuals or families that are statutorily identified as low and moderate income, correct?
Well, I believe what the decision from the ZBA says is that 20% of the units of this project would be set aside for what are, I believe the phrase is minority households. I believe that's the expression in the decision.
So they don't have to be low income.
I do not believe there is.
Well, I thought
anyone who would be in the project generally.
Maybe I got my facts wrong, but I thought all of the units were going to be low income, low to moderate, except for one, which was
that's
where
correct,
the manager was going to live.
That's correct.
So by definition, these units will be low to moderate as well.
That's true.
Okay.
What I'm saying is, if it turns out that adding an additional requirement, which is not, to my knowledge, required by 40B and may contravene some other law, can the project go forward? Can you sever out, cut that off, and still provide for a low and moderate income project?
I believe we addressed that point in our papers, and I believe the cases suggest that a reversal is appropriate, and that this Court, that separating out or severing that.
You're arguing, I think, that you ship it back to the trial court, which ships it back to the ZBA to reevaluate the project minus that condition.
That's correct, Your Honor.
I mean, they might decide, if that's not going to be permitted, that the whole thing should not be built. Or they might decide, well, okay, fine.
Right. I mean, the ZBA
we'll
being
build
a body that would shift personnel as time goes by, there would be clearly new people. So that's definitely a possibility, Your Honor.
Okay. Why do we have the wrong standard here?
Well, because
What is the right standard?
The right standard is the standard which would otherwise apply in the absence of 40B, which would be the local zoning laws in effect and such departure as could be obtained from those standards under the usual vehicles such as seeking a variance or a special permit.
Well, yeah, but that begs the whole question, doesn't it? This is 40B.
Well, but
I mean, if we find you can't use 40B after you get over the 10%, then we're back, you win.
Well, but I think you're combining 40B with the review standard. I'm sorry, excuse me. You're combining the comprehensive permit process with the regional needs standard, which is in the first section of Section 20. Oh. And actually, the statute as it's laid out separates very distinctly the comprehensive permit process in Section 23. It's by itself, There's no reference in that section to a standard of review. There's no reference to the regional needs standard of the first sentence of Section 20. In fact, what it sets out, it simply announces that all low and moderate income applications shall go through a streamlined process, and all boards which might have a say in a particular application are consolidated. So it's the one-stop shopping effect. It gives accelerated deadlines and requires that these low and moderate income applications be handled expeditiously.
Judge Sand spent a lot of time parsing the statute, as you well know. Where did he go wrong?
Well, I believe...
I mean, he said it's, you know, it's a little bit dicey and...
Well, I think the evidence is in Section 20. And Section 20 has the two sentences I would seek to... It's the definition of consistent with local needs, and that has two sentences. The first sentence says that the local zoning laws shall be considered consistent with local needs if they meet, and I'll just generally call it the regional need test, which is a balance of health and safety features balanced against regional need. In essence, that's what the test looks at. The second sentence then goes on to say that local requirements, local zoning laws shall be, it's a direct equation, shall be consistent with local needs when imposed by a local board in a town or city where certain minimum criteria are met. Those minimum criteria relating to area covered by square.
Doesn't all that, Mr. Garver, doesn't that section simply create an irrebuttable presumption? In other words, where you don't have low and moderate income, there's an irrebuttable presumption once the town has decided that this is an okay project under 40B.
In the case of exceeding or not meeting the criteria?
When you have less than 10%. Once you go over, you can still do it. You just don't have the benefit, as it were. The developer doesn't have the benefit of an irrebuttable presumption.
Well, that's actually, the regulations use something very much like that. They use a presumption that if you go up to the HAC and you have met the criteria, there's if you have not met the criteria, there's a presumption that's in effect in that agency that there is a regional need. I don't think that the statute contemplates that sort of a presumption. I think looking at Section 23, which is the comprehensive permit process, looking at Section 20, and in particular the language that talks about when imposed by a board, that local regulation shall be consistent with local needs, that they're clearly separating, they're putting on two different tracks towns and cities that meet the criteria and towns and cities that do not. And the question then becomes, well, what's the appropriate standard to use when you've exceeded the criteria, as Amherst did in this case?
Why isn't that sentence that starts requirements or regulations, why isn't that simply saying that the local board can deny the application if the 10% is met, but it doesn't suggest that they must? It simply means they don't lack jurisdiction to grant the comprehensive permit if they want to, if they've met the 10%. Why doesn't it just say that?
Well, I think in a general sense that's true, but what that doesn't address is what standard you're looking at when you go before the ZBA and you're in a town like Amherst that's met the 10%. Then the question is, what evidence do you need to put in? And the answer tends to be, well, as we look at the statute generally, the only test that seems to be written out anywhere is in the first sentence of Section 20, which talks about regional need. And I would want to emphasize...
Excuse me, Mr. Yes. Just I want to make sure I understand you. When you say when you go before the ZBA, are you talking about from a developer or a neighbor who's opposed to the developer?
Really either, because I think the standards would be the regional need is a very specific test in what it requires in terms of evidence. You need testimony about what is the regional need, health and safety issues. What I would like to emphasize is that when the legislature drafted this and they were looking for a way to bypass local zoning laws, really the mechanism that they chose is the regional need test. And if I could, I'd like to read briefly from the model rules which were used by Amherst, and this is at pages 2045 of the appendix. It's the model rules for comprehensive permits. And beginning at page 2049 is the following statement. Boards of appeals have found that it is most useful to enter into the hearing and decision drafting process assuming that a comprehensive permit will be approved. In that case, if there are significant local health, safety, environmental, or planning concerns, it can focus its attention on drafting conditions to address those concerns, only if it ultimately finds that there are no conditions which will adequately address the concerns should it deny the permit. And I'd just like to say it's a very difficult standard, the regional need test. It was picked by the legislature because it would, in all likelihood, override local zoning laws. It's a very tough standard. The question then becomes, why would that be the standard to be used for a project in a town that has met the 10% threshold? I mean, in effect, that's going to read the 10% criteria out of the statute. And
No, not actually. I mean, I'm just reading some language from the Board of Appeals of Hanover versus Housing Appeals Committee, which is the first case in which we interpreted the statute. We say very clearly that if once the municipality has satisfied its minimum housing obligation, the statute deems local requirements and regulations, including its restrictive local zoning ordinances, as consistent with local needs and thereby enforceable by the board if it wants to apply them. So, in this situation, only the board retains the power to override these requirements and regulations in order to grant such a permit. This result reflects the legislature's desire to preserve local autonomy once the community has satisfied its minimum obligation. But the local autonomy is in the ZBA. And at least what we say here, the ZBA retains discretion to override the local rules and regulations.
Well, but discretion must be bounded by some kind of standard. That's the question, really. I mean, I think we quoted that language in our brief to show that what remains open from Hanover is what is the standard that you use. Is it enough to say simply that the ZBA, when you've exceeded 10%, can do, in effect, whatever it wants?
Well, is that what they did here?
No, they followed the regional need. They did, and they is very explicit. If in the decision there's references to testimony about regional need, and clearly, I don't think there's any dispute at any level that they use the regional need test, and my understanding is generally that is, at least certainly in other circumstances, obviously the test, because that's what the first sentence of Section 20 tells you. But again, Hanover leaves open, and the Greenfield case leaves open. What standard do you apply? And I think, again, the first inclination is always going to be, well, there is this regional needs test. But I would submit that local autonomy would not be that the Hanover Court talks about local autonomy shifting back when you've exceeded the 10%.
It shifts back to the ZBA. That's what it's talking about here, so that the Housing Appeals Committee can't force the town or the city to accept this comprehensive permit.
Well, that's correct.
So local authority now controls, and the ZBA, as it says in italics, if it wants to apply them.
That's right, and the question then becomes, and that's I think the issue that we're trying to present on appeal, is what standard do you use in deciding whether the ZBA should apply, or as the second section of Section 20 says, impose after comprehensive hearing. What is the standard? Should it be the regional need test, or should it be the ordinary standards?
But you say that the regional need test. Why isn't it? I don't understand why it isn't the regional need test.
Because a couple of reasons. First of all, in Section 20, there are two different sections that describe what is consistent with local needs. There's two different sentences that talk about two different situations. The first sentence is the regional need test. Then the second stop, and then there's a stop, and then it begins again, and it says, and local law shall be consistent with local needs, where imposed by a board in a town where you have met the criteria. So they've divided the definition of consistent with local needs, which is the HJC standard. When you on a denial, you go up to the HAC. I think Section 23 says that is the sole issue, whether you are consistent with local needs. So then Section 20 is divided into two parts. Those towns that have met the 10% criteria and those that have not. And there is no test stated for the towns that have met the criteria. And again, in light of how the statute is generally put together, I would submit that it shouldn't be the regional need test that is employed, because that was picked by the legislature to be the mechanism to override the local zoning laws.
Mr. Garber, would I be correct in understanding that when you say you go back to the regular zoning requirements, I
Yes.
think that one aspect of that is that you cannot get a comprehensive permit. You have to go through, the building inspector,
Not at all. Well,
Okay.
I'm sorry, in a town that exceeds 10%?
Yes.
You're right. I believe that Section 23 is unambiguous that all applications, whether you are in a town with 10% or less, or whether you've met the square footage criteria, that all applications go through the comprehensive permit process.
Okay, so you go, so that it's not back to the old thing in that sense. So you can get a comprehensive one.
Yes.
But then it's as if you package all of the requirements of the, the little chip chop that, the fire department and the building and that, whatever that you have to sign off seriatim.
The consolidation
They put them in,
is
but they should
required.
still be the same, as if you were going through them seriatim.
I believe so, and I believe the statute,
Okay.
in looking at how Section 23 is drafted as compared to the rest, it speaks only in terms of low and income housing applications, gives the streamlined process, the accelerated deadlines. All low and moderate income applications have the benefit of that statute,
Okay.
whether you're in a town over or under the criteria.
Thank you, Mr. Garber.
Thank you, Your Honor.
Mr. Pinto?
Good morning. May it please the Court. Donald Pinto. I represent the Appalese HAP, Inc. and Richard Bogarts. I'd like to address the notion that the Court first raised with Mr. Garber about the provision of the comprehensive permit that the Court referred to as a racial quota, and I'd like to take issue with the notion that this is a racial quota.
No, it's a minority quota, but my question remains the same. What authority was there for the board to adopt that?
Your Honor, the Board certainly doesn't express what it believed its authority was, either in the two-page permit or the accompanying explanatory decision. But what I take issue with is characterizing it as a quota. There is a two-page permit which lists in very summary fashion the basic terms of the permit, and in that document it has language saying 20% of the units will be set aside for minority households. However, in the 12-page decision that accompanies the permit, that language is somewhat watered down, and referring to the same requirement, it says about 20% of the units will be reserved for minority households. It goes on to say that HAP must apply to the Department of Housing and Community Development for approval of these restrictions. So it suggests that the ZBA was recognizing that this was not a done deal, that these were restrictions that would have to be approved and might not be approved by DHCD. Further, and this is also covered in my brief, Your Honor, a racial quota or a minority quota is only a quota if it's applied as a quota. And there are many federal cases that cover this distinction between what they refer to as a rigid, unlawful quota and a flexible goal. And I would suggest that the language, particularly in this 12-page decision, suggests more of a goal rather than a rigid quota. But in any event, you don't know whether you have a quota or a goal until you see how it's being implemented. And that's a long way away on this project, which has been in litigation now for 5 years and is at least several years from now before it's actually built. There's no guarantee that this provision will ever kick in, because it's possible that the pool of applicants for this housing will well exceed 20% minority households, whatever that means, and so the provision will never actually apply. And my last point on this issue, Your Honor, is that most importantly, none of these plaintiffs have standing, as the land court found, to raise this issue if it is a quota or it is a goal. They put on no evidence whatsoever concerning this issue at trial, and in fact the issue was first raised in the appellant's post-trial brief. So the appellees had no opportunity to respond to the issue and to test the plaintiff's appellant's standing at trial, but there was trial evidence that all of these appellants own their own homes in the adjacent neighborhood, and there's no suggestion that any of them are ready or able to apply for housing and might conceivably be discriminated against by this provision if it were to apply to them.
Mr. Pinto, it would be turning to the underlying one. It would be helpful for me if you could address the point that I last raised with Mr. Garber, namely, once you get the 10%, once the town has reached the 10%, if it's a low and moderate income project, you get the benefit of the fast comprehensive permit, but you don't get the benefit of waiving high density, other kinds of restrictions that are in the existing bylaws, building requirements, whatever it is.
Yes, Your Honor. This Court, in fact, addressed that very issue in the Hanover decision, which, as the Court knows, was a very detailed, comprehensive analysis of the statute and how it was meant to work, and particularly the 10% statutory minimum and what effect that had once that minimum was reached. And the Court observed that streamlining the permitting procedure wouldn't nearly suffice to promote the statute's goal, which was clear from the legislative history of creating more affordable housing. So this Court looked at that issue and clearly found and said so in the Hanover case that simply aggregating the permitting process before one board and saving some time and saving some expense on the applicant's part would not serve the critical statutory purpose of creating more affordable housing. It's the override, the power to override the otherwise restrictive local zoning ordinances like minimum lot sizes and maximum lot coverage and building heights, side yard and other setbacks. That's really the mechanism that makes the statute work and is critical to actually creating affordable housing. So I suggest that the Court has spoken to that issue in Hanover, and I believe in some of the decisions since that cite Hanover with approval.
But the state has no power to do just that when the town already has 10% of its housing stock low and moderate income. So we're at that point now. The state doesn't have that power to override local zoning ordinances.
That's right. Once the 10% threshold is reached, the presumption goes from a presumption that the community has an insufficient amount of affordable housing to a presumption that it has enough affordable housing, but local autonomy is preserved for that community to decide, in our community, our local needs are more than 10%. Our local needs require 15% or 18 or 20% affordable housing.
So what is this? The question I think that was asked was, what is the standard that the board therefore uses in making that determination? We're over 10%, but...
It's the same standard, Your Honor. It's the local needs test. It's the only test that exists in the statute, and there's no suggestion anywhere in the statute that a different test applies when the community goes over 10%. And I think this also was covered in Hanover.
Is this local needs, regional needs, are they the same thing?
Well, I believe the way the statute is structured, that it's the defined term is consistent with local needs, and within that definition, there is reference to the regional need for affordable housing as being part of the definition of local needs, and that's how both the local and the regional needs
So you would say
come
that in determining local needs, you consider regional needs?
Yes, Your Honor.
Regional needs is a part of it.
That's as prescribed in the statute in that definition in Section 20. So in a community that's over 10%, again, the important factor that the legislature had in mind was to restore local autonomy once the community satisfied one of the statutory minima, including having 10% affordable housing. But the language in the Hanover decision that Justice Cordy cited to my brother really could not be clearer, that the legislature included the words, when imposed by the local Board of Appeals, and this Court has already construed that language to mean that the board, and only the board, meaning the local Board of Appeals, has the power to override these restrictive zoning ordinances. The appellant suggests that the reference to overriding was only a reference to the local board's traditional power to grant special permits and variances, and there's just no support in the Hanover decision for that position. The court was talking about overriding these requirements, referring to, again, to minimum lot size, maximum lot coverage, building heights, in a community that was below 10%, and then in the next paragraph, the court turned to the situation where the community is above 10%, and again was referring to the power to override these requirements. It just can't be that the court was intending in that next paragraph to use the same language to then refer to the traditional power to grant special permits and variances. Your Honors, this case really is an ideal vehicle for the court to reaffirm what it already said in the Hanover decision almost 40 years ago, and that has been said since that time by this court, by the appeals court, by a number of the trial courts, albeit not in a case that presents the issue so squarely. The reason it's an ideal vehicle is first because it does present the issue squarely. Secondly, it involves a developer that's a nonprofit that's dedicated to the creation of affordable housing. So unlike many Chapter 40B cases, this is a nonprofit developer that's going to develop 100% affordable units in this development, 26 affordable units. And the case also comes to the court from a community, the town of Amherst, that even though it's reached the 10% threshold, still has a very dire need for affordable housing. So the local needs in Amherst require more than 10%, and that was the decision that the community made in endorsing this project.
So your argument is essentially that the Board of Appeals can override the restrictive zoning requirements, taking into consideration local needs, which takes into consideration regional needs as well.
Yes, Your Honor, as well as the other factors that are included in that definition, which have to do with health and safety of the occupants, but both the occupants of the housing and the residents of the local community, proper site and building design, et cetera. There are a number of factors in that definition, and again, it's our view and it's this Court's view per the Hanover case that same definition and those same standards apply whether the community has reached the threshold or not. Your Honor, our position, unlike the appellant's position, has the virtue of not requiring any gymnastics in interpreting the statute and the statutory language, particularly the language when imposed by the local zoning board of appeals, and it also has the virtue of satisfying the clear legislative intent of creating more affordable housing. So we would ask that the court affirm the land court decision and allow this project to go forward.
Thank you, Mr. Pinto.
Thank you.